Good morning. Thanks for coming out this morning, and I would like to thank the Center for this really fascinating conference and for including me in it. Thank you very much. So, the Civil War saw a massive expansion of both government and executive power, the greatest expansion in American history to that time. This was not because Abraham Lincoln came into office seeking more authority for the executive branch, but because necessity dictated that. And one of the things to keep in mind about executive power is that the greatest and largest claims to executive power always come during times of war, or something like war. As we talked about yesterday, we don't call our military actions war very much anymore, but these periods in American history are when there are the greatest claims to executive power, and quite frankly, the moments when executive power is most inclined to abuse. Even in the middle of the Civil War, though, Abraham Lincoln's political opponents roundly criticized this accrual of power, both to him and to the executive branch, and they routinely accused Lincoln of tyranny. And that was the word that they used routinely, was tyranny or tyrant. Their rallying cry became the nation as it was and the Constitution as it is. So what they were trying to do, they said, was defend America's personal liberties as they were enshrined in the Constitution. Now, the power of the president changed in two different ways under Abraham Lincoln, and I'm going to talk about both of those. The first was the power that Lincoln himself claimed, the things that Lincoln himself did. The second are the powers that Congress gave to the executive branch. And first here, then, I'm going to talk about what Lincoln claimed for his own powers. Lincoln talked a lot about wartime powers that the Constitution gave him. There is no such term in the Constitution. His enemies greatly disputed this claim even at the time. They thought that he was aspiring to become a king. They accused him of virtually shredding the Constitution. And it's not clear that the Constitution grants the sweeping powers that Lincoln claimed. But at this point, precedent has taken hold. And what we see now in our own time and in the years since the Civil War is that many presidents have cited Lincoln as a precedent for claiming similar powers. So what did Lincoln do? Among other things, he called up troops in the days immediately after the firing on Fort Sumter. This is actually a power that the Constitution gives to Congress. He declared a blockade on southern ports. This is often considered an act of war, and the president doesn't have the power to declare war. That is also left to Congress. He suspended habeas corpus, first from Philadelphia to Washington, D.C., then along the East Coast, and ultimately across the entire North. Now, there's a question about who has the power to do this. In the Constitution, the suspension of habeas corpus is listed in the section where the framers were discussing the powers left to Congress. But they put this particular section in the passive voice and said habeas corpus may be suspended. But by whom? It's silent on that. Congress ended up resolving this by essentially rubber stamping Lincoln's claims to power and to this particular power, and they approved his suspension of habeas corpus after the fact. The Emancipation Proclamation is a huge example of Lincoln's claim to executive power. There's a real argument out there that Lincoln was impinging on constitutionally protected property rights. But he claimed this as a war power and a consequence of the war. Those are the things that Lincoln did. And let's talk about the powers that Congress gave to the executive branch. The income tax, which it's bizarre to think about today, but it's true, was actually demanded by the Northern public. They wanted an income tax. Greenbacks, or paper money. At the time, money was often issued by local banks. Now you had a unified national currency. And this too was something that Congress had passed. Acts involving the settlement of the West, the Homestead Act, the Morrill Act, which established land-grant colleges, the Transcontinental Railroad. All of these are actions that the executive branch then has to administer. And finally, the Enrollment Act, which really created the first draft in American history. This is also the first time that the federal government, and not the states, has the primary responsibility for raising troops. And this is part of what had been a gradual shift, a series of experiments in trying to get the states to be more competent at raising troops. And finally, it became clear that they were just unable to do that. And so it moves then to the responsibility of the federal government. The Enrollment Act also creates an agency that is effectively the first domestic intelligence agency in American history, although no one quite realized that at the time. Nobody was really talking about that, but with the advantage of hindsight, we can see that this is actually what was going on. Now, the center asked me to talk a lot about reaction to these activities on the part of Lincoln and of Congress. And so that's what I'm going to spend the rest of my time talking about. Resistance came primarily from a group called the Copperheads, otherwise known as the Peace Democrats. The Copperheads typically came from three different segments of society. One were people who were born in the South or whose families emigrated into the North from the South. So they had some sort of Southern connection. They typically did not have a problem with slavery. The second group were immigrants and Catholics. And if you think about that as a Venn diagram, there's a lot of overlap there. But these are people who had been targeted by Protestant reformers who had often been in the Whig Party, or nativists who had been in the Know Nothing Party, and both the Whig and the Know Nothing parties, those members tended to migrate into the Republican Party when it was founded in 1854. So there wasn't a lot of love lost between many immigrants and many Catholics and the Republican Party. And they saw this very much as a Republican war and wanted no part of it. They were also deeply concerned about the prospect of African Americans coming north in large numbers and taking their jobs for less pay. The third group that we're talking about here were people who had a very conservative understanding of the Constitution. They would have a lot to talk about with Justice Scalia, for instance. They did not believe that the Constitution was elastic at all. And so they thought that Lincoln was far, far, far outside the bounds of where he should be with these actions that he was taking. The size and influence of this Copperhead movement waxed and waned over the course of the war, usually in inverse relationship to how the Union troops were doing in the field. So when the war was going badly for the North, the influence of the Copperheads was on the rise. What you see, regardless of what the background was of these people, is that the Constitution becomes the common language that they all speak. They come together around Constitution talk and questions of constitutionality. They're also talking about race, and even by the standards of their own time, their comments on race are particularly vitriolic. But you see that sort of commentary far less than you see these questions of constitutionality and these claims that they are trying to protect American constitutionalism and not trying to undercut the war effort, which is, of course, is what Republicans are claiming that they're trying to do. Okay. There is criticism toward Lincoln from the very outset of the war. George Pendleton, who was a congressman from Ohio, said that if Lincoln could raise troops and suspend habeas corpus, he could, and I quote here, supersede entirely the Constitution and the laws. Another Ohio congressman named Clement Vallandigham sought in July of 1861 to have Congress censure Lincoln for 7 actions that he thought that the president had committed unlawfully. The Republicans who controlled Congress the entire time Lincoln was in office tabled this measure, and it never got anywhere. But there was a steady drumbeat of criticism from the outset of the war. Now, Copperheads claimed in the first year and a half of the war that the real object of the war was not to maintain the Union, as Lincoln insisted, but to get rid of slavery. And so for them, the Emancipation Proclamation was a perverse victory because they could say, I told you so. At the same time, though, they were saying that it was a completely unconstitutional act, that it was a gross violation of property rights and a tremendous overreach for the president. Now, Lincoln anticipated this kind of criticism, both from peace Democrats and from war Democrats. And so he claimed the Emancipation Proclamation as a war necessity, that this was a military necessity. This was the best way for the Union to strike at the soft underbelly of the Confederacy. You have 4 million allies behind enemy lines. Why not use them? Why not motivate them to leave? And 500,000 of them do. Why not motivate them to act as spies for you? And they do. Or as scouts, and they do. They're a tremendous resource for the Union Army. But this is why the Emancipation Proclamation does not have this ringing rhetoric that, say, the second inaugural address does. It's written like a legal brief because he is making a legal argument for why he can do this. Now, his critics don't buy this at all. Horatio Seymour, who was at the time running for the governor of New York, said that the Emancipation Proclamation was a proposal for the butchery of women and children, for scenes of lust and rapine, of arson and murder. And a Long Island newspaper editor said that it imperiled the liberty of white men. Now, the other major alleged violation of the Constitution was conscription. And this was because it was the claim was that this was a vast impingement on personal right of movement. Even Horace Greeley, a famous Republican editor, said that drafting was an anomaly in a free state. And of course, this created a great deal of unrest in the North. Not the least was draft riots in various parts of the country. Well, in the summer of 1864, when things are going very badly for the Union armies, the Copperheads are really on the rise. They have now unprecedented power in the Democratic Party and very nearly take over their own party. They get a plank into the party platform, calling the war a failure and demanding an immediate cessation of hostilities. They leave their convention on August 31st, convinced that they're going to win the November election in a landslide. And by the way, Lincoln agreed with them. That's August 31st that they leave Chicago. The night of September 1st and 2nd, the Confederates withdraw from Atlanta. And public opinion does a 180, literally overnight. Suddenly, what looked like a slam dunk for the Democrats is anything but. And this election is, in fact, a landslide for Lincoln. But his actions create an important precedent that the people who followed him in office used and cite regularly, even now. The difference is that unlike many of his successors, Lincoln's actions were incremental. Even on the Emancipation Proclamation, there had been baby steps toward it all through the war, both by Lincoln and by Congress. The suspension of habeas corpus, likewise, incremental. The important thing to keep in mind about Lincoln is he was a raging moderate. He didn't want to make grand claims to power. He responded to necessity. Note the difference between how Lincoln acted and how, say, FDR dealt with Japanese Americans on the West Coast. Bang, they're all in camps. There is no incrementalism there at all. So, this tees up Professor Turley. And with that, I will leave the podium and let him talk about what Lincoln's successors did with this power. Thank you.
Thank you very much, and thank you, Jennifer. It's been a really delight to spend time with Jennifer, whose scholarship is really fascinating. As I've said before, it's always a thrill to appear with Lewis, who I'm not too sure students really appreciate what an iconic figure Lewis is for constitutional scholars. And he has been a voice of clarity on separation of powers for decades. And of course, it's a great honor to have Sir Christopher here. And if you were not able to see his remarks yesterday, I'm sure that they're recorded, but you really should watch them. He is, of course, a towering figure when it comes to international law. And it's a credit to the program and its director, Rick Griffin, and its acting director, Andy Biddy, this incredible collection of academics from around the world have been gathered here. I, I can't say, I can certainly say I'm not here to praise Lincoln. I'm not here to bury him either. Um, I have always had a more nuanced view, to put it lightly, of Lincoln's time as president. He is, of course, the ultimate icon for the United States, for the world at large. He's the very face of defiance in terms of dividing the nation, but he is also the face of emancipation. And for that reason, we often look over or look beyond the actual legal basis for his actions. Wordsworth once said, when someone wrote about one of his poems, it said, "I really love your poem," and he said, he expressed doubt that he really loved the poem. He said, I think you merely agree with the verse. What he was saying is that you're really not looking at the poem, you just like what it says. The same can be said about Lincoln's legacy. We like the Emancipation Proclamation. We like the unification views of the country. The fact is, however, that Lincoln acted grossly unconstitutionally. He acted not just without authority, he acted in direct violation of the Constitution that he was sworn to uphold. I am not one of those who believes that these are small transgressions that one has to consider in light of the context. Presidents always claim that a given context or emergency gives them license to exceed the Constitution. But when they do so, they don't just become one of the dangers the Constitution is designed to protect, they become the danger that the Constitution is designed to protect against. Now, the interesting thing is that from the very beginning, Lincoln used his considerable legal skills, and they were considerable, to adopt fairly sweeping views of the Constitution. A good example of that is his debate with John Calhoun. I did a piece a long time ago. I actually had to look it up this morning, and I was embarrassed how long ago it was. But he had an interesting debate with John Calhoun. And once again, I have to say with Lincoln, you have to give him credit. He wanted these debates. He engaged in a level of debate in Congress over secession that most presidents would not. He wanted to convince people to lay out his case. And he did it in front of Congress, and the case was magnificently laid out. And it was all Lincoln. This was not the age of speechwriters. Not that any speechwriter could really meet the level of Lincoln himself. But what's often forgotten is the arguments of John Calhoun in opposition. And if you look at John Calhoun's arguments, they are not unreasonable. There is a significant question that existed at that time, whether states could secede from the Union. And if anything, I think Calhoun might have had the better argument, but it was a close one. And the point is that on this issue, you can't criticize Lincoln as much because this is a question that I think was in equipoise. But the funny thing is that people have long kicked John Calhoun into the dustbin of history. And that's once again an example of how the winners write history and the losers are often forgotten. But John Calhoun, for all of his failings, was himself a great orator, a great legal mind, and the arguments against secession were quite solid. In the end, I think many of us might be persuaded by Lincoln. But on these other issues, Lincoln was not arguing issues in equipoise. Even his famed announcements of Emancipation Proclamation that we all celebrate was based on largely a fiction. You know, one of the most memorable lines is that America is dedicated to the proposition that all men are created equal. There's no greater line spoken by a president of the United States. It's also entirely untrue. There are many propositions that we may have been dedicated to since the founding of our country, but equality was certainly not one of them. The presence of slaves throughout our country evidences that equality was hardly a proposition upon which everyone would agree. Lincoln was simply changing the legacy that he had inherited. He had, in many ways, reinvented the republic that he had received in a better image. We would all love to believe that America is dedicated to the proposition that all men are created equal. But we are not as good as our press, as they say, and we're not as good as the Gettysburg Address would have indicated. But the president certainly went forward from the beginning of just before the Civil War in asserting an unconstitutional, actually a routinely consistent unconstitutional assertion of power. That included the calling out of troops, the enlargement of the military, all without congressional authority. He called out the militia to, quote, suppress combinations. Which is an interesting way to put it. Indeed, words meant a lot to Lincoln, and he knew it. He avoided calling this a civil war, even though we always call it a civil war. Lincoln knew better than to call it a civil war. He called it a rebellion because he wanted to suspend habeas corpus. But the writ of habeas corpus is placed clearly in Article 1, Section 9 in the powers of Congress. Now, some, what I would call Lincoln apologists that are quite respected for good reason, like Richard Nelson Current, has written that, well, you know what, the presence of the writ in Article 1 was really an accident because, quote, they had nowhere else to put it. I have to say I don't subscribe to that. I think it's awfully silly. If you trace the great writ from our predecessors in Great Britain, it made abundant sense for it to be placed in Article 1, but certainly that is how the framers viewed it, in my view. It was without question, but more importantly, there's a consistent line of cases on habeas corpus that made it clear that only Congress can suspend habeas corpus, and those cases preceded Lincoln's action. So the court had already established that only Congress could take this act. But Lincoln was concerned about Maryland in particular. There were many people in Maryland that were Southern sympathizers. Maryland was the key railroad hub, and he needed Maryland as a transfer point, cross point for troops, for resources, in order to prosecute the coming war. So he's particularly concerned about Maryland. It's one of the reasons why he ordered or allowed to be ordered the suspension of habeas corpus first in Baltimore and then New York. And then he went further, which gave General Winfield Scott the ability to suspend habeas corpus, including against legislators in Maryland. And so this began in the worst possible way with the arrest of Maryland legislators who simply opposed the war. And when you read the suspension, it is truly shocking that people who, quote, discouraged volunteer enlistment, so simply discouraging people from volunteering was enough to have you arrested. Disloyal practices, whatever those may be, giving aid and comfort to rebels were all grounds upon which you could be arrested. And that included John Merryman, who may have in fact been a traitor. But when Merryman went and filed a habeas corpus petition, it ultimately went to Chief Justice Taney, who was, despite some of his more infamous rulings on this, was exceptional. And Taney made clear that the president could not suspend habeas corpus, and in fact issued an order for the appearance of Cadwalder, who was the person that was responsible for incarcerating this individual, to appear before the court. And then there was what I think to be one of the most telling moments during this period, and something that would foreshadow what we see with modern presidents. Because the single marshal that was sent with papers to collect this executive officer stood outside the fort and was not allowed in. And he stood there looking up at this fort where he was told that he would not be able to serve his papers. It was the personification of this conflict, a judicial officer seeking to serve legal and correct papers, and a president who is essentially walled off in a fort. And indeed, the papers were not served. But Taney said quite clearly that, quote, a state of rebellion is the only time when Congress could declare the writ removed and said that this article is devoted to the legislative department of the United States. It is not the slightest reference to the executive branch. Taney was speaking that there was absolute clarity, and Lincoln knew it. Now, there's a great history here that we can certainly discuss in our Q&A, but my greatest criticism of Lincoln is that he laid the foundation for unchecked presidential powers in wartime. And it is a legacy that is rarely attributed to Lincoln, and one, in my view, that dramatically counterbalances the obvious positive and indeed heroic aspects of Abraham Lincoln's tenure in office. It ultimately blossomed in a very ugly way in World War II under Franklin Delano Roosevelt, who claimed the right to imprison, try, and execute even American citizens without any access to the courts. The case that I'm referring to is In re Quirin, which in my view is one of the most disturbing cases that the court has ever dealt with. It also shows how the Supreme Court is not a particularly good custodian of constitutional rights. This case was based in World War II, the so-called Operation Pastorius. This was an effort of the Nazis to land submarines, 2 of them in the United States, and unleash saboteurs upon the nation. Each of these submarines had teams that were highly trained, had large amounts of explosives. One of them landed at Long Island. 2 of the people in that boat were, in fact, American citizens, Ernest Peter Berger and Herbert Haupt. But the most interesting character in that boat was the leader, a man by the name of George John Dash. And Dash had secretly viewed the mission as a way of getting the heck out of Nazi Germany. And it turns out that he was planning all along to reveal the operation and to go to the FBI, which he did. Before he did that, by the way, he saved the life of a Coast Guardman who came upon this group of saboteurs bearing their explosives. And the Germans told Dash they had to kill this man. And Dash intervened and stopped them from killing him, and then, rather cryptically, told the Coast Guardman, "Remember my face. Now, basically, get out of here." And so the coastman went and told people about this. And by the way, nothing happened. They basically filed this report, which led Dash to be somewhat curious about why no one was coming by. And so he ended up, believe it or not, going to the FBI and saying, "I'm a German saboteur here to blow up your factories." And they took a report and said, yeah, and sent him along his way. Dash then went and dug up the money, brought it back to the FBI and said, "Look, here's $150,000. Does that show that I am a saboteur? Why would I have this money?" Finally, the FBI believed him, and they proceeded to capture most of the saboteurs. What followed was one of the darkest histories in U.S., darkest chapters of U.S. history. Hoover, J. Edgar Hoover, claimed that the FBI had found the saboteurs all on their own and eliminated any reference to Dash. He was heralded by FDR, and FDR ordered the men to be executed without a trial. It ultimately led to very brave lawyers going to the Supreme Court, and there they met with what was only gross injustice built on many of these extreme ideas of presidential power. Roosevelt citing Lincoln and others and saying that he has absolute power in wartime, the courts have no power. He had the support of a justice that I would probably say I'm probably one of the leading critics of. I find no redeeming qualities about him, even though law professors seem to love him, and that is Felix Frankfurter. And Felix Frankfurter has almost an absolute perfect score, in my view, of not only some of the worst opinions ever to come out of the Supreme Court, but an absolute absence of any notion of judicial ethics. And Frankfurter met secretly with the Roosevelt administration, helped them plan their case to the Supreme Court, never telling his colleagues. To make matters worse, Murphy on the court actually showed up in an Army uniform for the hearings. It was just incredibly embarrassing. And Frankfurter almost threatened his colleagues to say, Roosevelt, if we say that we have jurisdiction, Roosevelt will simply take these people out and have them shot. So the best thing is just say he has the authority, a rather curious argument to be sure. But it is part of the legacy of Lincoln that these presidents have claimed that in wartime they have near absolute authority. And that, of course, gave full blossom under George Bush in the creation of the enemy combatant statutes. And the notion that the president can build a prison just a few miles off of our shores and deny people due process to try them in military tribunals, even though there are available courts less than 90 miles away. So how does this all then turn out for not just the Constitution, but the citizens at large? It brings me to one of the most curious moments that I have witnessed, and it was at my law school that I graduated from, when Attorney General Holder went to Northwestern to unveil the new policy of the Obama administration, the so-called kill order policy. And Holder proceeded to tell an audience of esteemed judges and law professors that the President of the United States now claimed the authority to kill any of them based on his unilateral authority, period. That the President of the United States has authority to kill any American citizen that he considers to be an imminent threat to the United States. Now, you would think in the United States, in this republic, that a president telling an audience of lawyers and judges that he reserved the right to kill any of them would get nothing more than tepid applause. And instead, he got a roaring round of applause. It was a bizarre and it was an incredibly unnerving moment. And in my view, it's Lincoln's legacy. That people in that room believed that the President of the United States had the authority to suspend every possible part of the Constitution based on his sole judgment that somebody is a threat to the country, even without a declaration of war. So whatever Lincoln may mean to us historically, I think that he's a far more nuanced and complex figure. And in some ways, it's better for us to see him as he was, extremely flawed. He made the wrong choice. We didn't need the suspension of habeas corpus. What's fascinating is when everyone says Lincoln suspended habeas corpus, they rarely look at the fact that we really didn't have to. And most certainly, he didn't have to do it unilaterally, that Congress would have suspended habeas corpus. And like many excessive uses of executive power, it was completely unnecessary. But what it created, and what it is still maintaining, is a troubling expansion of executive power and an unchecked claim of war powers that plagues this country. In the end, when we are at war, we are fighting for something more than just our security. Security is easy to maintain. We're fighting for something that we believe, a common article of faith, and it's that Constitution. What is odd is that when we go to war, presidents tend to view our Constitution as a weakness instead of the thing we're trying to protect. It is possible to have a constitutional war, and we have proven that over and over again. So let's not necessarily celebrate Lincoln's actions. Let's understand them. But let's at least condemn those actions that exceeded his oath and exceeded the Constitution. Thank you.
I'm going to give two quick questions to our speakers and then turn to you. My first question to both has to do with Jennifer Weber said that the critics of Lincoln called him a tyrant and aspiring to be a king. Jonathan Turley said that Lincoln's actions were grossly unconstitutional. And much merit to both sides. But the one thing I thought that Lincoln said, and I just want the two of you to talk about it, when he took all those unilateral actions, and then he called Congress back into session on July 4, 1861, he said something that I thought showed respect for the Constitution. Namely, he says, I don't think I did anything beyond the, quote, constitutional competency of Congress. So he is saying publicly and to Congress, I did go beyond my Article 2 presidential powers. I used Article 1 congressional powers. Therefore, since I did that, the only way what I did can be made constitutional legal is for you to pass retroactive authority, which is what Congress did. So I just want to see if you two think that is at all satisfactory or significant. And secondly, just quickly on the Emancipation Proclamation, I want to ask you too if you think that we focus way too much on Lincoln's action, because I think as both of you indicated, he went last. Congress went first. Congress passed two confiscation acts. It eliminated slavery in D.C. It took other statutes. And actually Lincoln, as I understand it, was worried about Congress acting too quickly. So do we focus way too much credit on Lincoln and not enough on earlier actions by Congress? You two can stay there and just comment on those two questions.
All right. So, yes, Congress did approve all of Lincoln's actions that he had taken up to July 4th, 1861, when they met in session. Now, there's an argument to be made that Lincoln dawdled in calling them back into session. He waited a while to do that. He didn't necessarily have to do that, but he did. And so you can criticize him legitimately for that. On the question of habeas corpus, Lincoln's response to that was likening the country to a patient who had, say, a gangrenous limb, and that in order to save the patient, you had to take off the limb. And that was what he said justified his suspension of habeas corpus. Now, there's a really interesting study on how and where most of these habeas corpus cases came from. And most of them, and there were thousands of them, they were mostly in the border states. And you may call me a Lincoln apologist, that's okay. But these were states where loyalty by definition was questionable, and where it was not unusual for either a judge or juries or both to decide against the federal government simply because they were Confederate sympathizers. And that happened. And I do think that there is a case to be made, an argument to be made, certainly, that this was an extreme moment in American history. That is not to say I'm comfortable with all of this. I'm really not. It had a fortunate ending in that Lincoln was, I think, very responsible with his use of this power in ways that subsequent presidents have not been. And Lincoln, as soon as the war was over, those powers went away, as promised. The agency that administered and enforced the draft went away, as promised. And that was fortunate. The problem with Lincoln's successors, it seems to me, is that, and not that it is reasonable to expect them to do this, because they will, I think most of them will take as much as they can get. But nobody's factoring for the dimension of the threat to the country. And I would say that, for instance, the immediate threat to the country after 9/11 was not that great. These were significant terror attacks for sure, but the continued existence of the country was not in question. And in addition to what Professor Turley cited, I would add the Patriot Act. which allows the federal government to basically spy on all of us without a warrant. I think that's really problematic. The difference is that the Civil War was an existential threat to the United States, certainly as it had existed to that time. The only other existing republic in the world at that time was Switzerland. The question of whether a republic could succeed and survive was still an open one, very much so. And there was a great deal of concern about what would happen if the Confederacy succeeded. I think it's entirely possible that you would have seen the Midwest leave the United States, and then the Pacific Coast states also leave the United States. That's all supposition. But what we're missing in subsequent presidents is a sense of scale. And so when they cite Lincoln as a precedent for their actions, their interpretation, in my view, is skewed and inaccurate because they are not taking into account the conditions that Lincoln faced at the time. Okay. I can't remember what my notes here mean. Oh, well, did I answer both of your questions in there?
Yeah.
Okay.
Jonathan?
Yes, you're a Lincoln apologist. Jennifer's a friend, but I have to say, in a true Lincolnian moment, a divided panel cannot stand, and I think you should be arrested and sent to a fort. I don't agree. First of all, I don't think that you can credit Lincoln for any of these things, including going to Congress to say basically, my bad. It's time for you to essentially ratify what I have done in your name. He's not allowed to do that. That's like a bank robber going and saying, it's not bank robbery if you just give me the money. Now, a victim may do that, and that certainly might work, but that doesn't redeem the original violator. He violated the Constitution. He has no authority to exercise Article I powers. And I don't agree that just because he let habeas corpus return gives him credit either. It's like saying, it's true, I had a passing tyrannical moment, but I'm back. Of course, it wasn't back in that sense since he never finished the performance of My American Cousin, but at Ford Theater. But certainly we returned habeas corpus. Lincoln showed utter contempt for Article I. A good example is that, he suspended habeas corpus in New York and Philadelphia 2 days before Congress was going to convene. So he wasn't waiting for Congress. 2 days before they actually came in, he suspended into other major cities. So I don't give him credit for any of these things. And also in terms of being a moral relativist, let's remember Lincoln said at the outset of the war, I declare that I have no purpose directly or indirectly to interfere with the institution of slavery where it exists. I believe I have no lawful right to do so, and I have no inclination to do so. So when he later said in the Emancipation Proclamation that he was dedicated to the proposition that all men are created equal, that was a completely different Lincoln than when he first came into office. So I'm afraid that I don't share the view that this was a redeeming moment at all.
From the audience. Okay. There's a microphone coming.
Sorry. I would direct my question to Ms. Weber, actually. I'm just kind of curious how I kind of see it as a justification of Lincoln's behavior, regardless of the scale at the time, versus subsequent presidents who have utilized the same argument and power. How do you kind of find justification between those two?
I'm mindful of the context that he was working in, and that's really what I'm thinking about, is the size, the magnitude of the threat that the nation faced at the time. That's what I'm thinking of.
I follow that up?
Sure.
I guess I still, even looking at the magnitude of it, from my perspective, it's still an abuse of the power. And wouldn't it have been better to not abuse the power and let the power be as it may, to whatever end, rather than to set this precedence, which now enables continual abuse?
Well, that assumes that the country would survive the Civil War.
Well, that's assuming maybe that it wouldn't also. And I mean, that's assuming that surviving it under that context was a good thing.
So would you argue then that the country falling apart would be preferable? But that the law be maintained, that this law is fully honored and respected, and I understand the argument there. I'm not completely unsympathetic to that argument. I understand that.
And that's the first step.
Yes, yes. My name is Jenny.
I'm a Lincoln apologist.
Yes.
I guess it's for me, I look at it in terms of, we have this republic that we want to save, but in order to do so, we're going to employ powers that have nothing to do with everything that we stand for. And to me, I can't find the justification in that. I think, absolutely, I would rather see a nation crumble and rebuild under a consensus of ideas that that's agreeable to everyone, than to have someone usurp authority that they don't have unilaterally, and to watch subsequent presidents continue doing the same thing.
Well, I don't know to what degree you can hold Lincoln responsible for what subsequent presidents do and how they use and abuse the Lincoln legacy. Now, among Lincoln scholars, there is a phrase called, and it is getting right with Lincoln. And you see all kinds of politicians, presidents, companies citing Lincoln, using his name as a way of getting what they want. That's on them, not Lincoln, it seems to me. Now, to me, as I said, the big problem is the taking into account the context in which Lincoln was working. And yes, they're citing Lincoln as a precedent. They are not talking about the size of the threat that Lincoln was facing. World War I was not an existential threat for the United States. And yet Woodrow Wilson cites Lincoln and says that he can imprison socialists and immigrants as a result of that. I'm more inclined to hold Wilson responsible for that abuse than Lincoln.
Let's move to some
Can
other
I
questions.
do one follow-up?
Go ahead.
You're in his camp.
No, I'm delighted, and she's not a plant, I swear.
Check is coming later, though.
Although this image of all of you historians getting right with Lincoln, I just see this sort of passing around some anatomical doll to tell Lincoln all the things that you really wanted to tell Lincoln to get right with him. I think it's actually an impossible task. And the reason is that, first of all, we can actually question whether the Civil War is an existential threat. I think the Civil War could only come out one way. And this actually, I'm a sort of military historian nut, and I've never actually agreed that the Civil War is an existential threat. I think that the North was most certainly going to win that war regardless. They had the population, the industry. It would have been an unprecedented historical act for the South to actually prevail ultimately. The question was whether another million men would have to die. But I think the South was never going to prevail, but we could debate that, and that would be that's the next conference. What I wanted to add is I loved the point of, let it fail if it has to fail, rather than become something we are not. The siren's call of liberty from any leader is that I face an existential threat. It is consider the context. Every leader claims this is an existential threat. It is a siren's call of citizens to give up their liberty. And I think that we have become a nation of chumps. We accept that, even when it's manifestly not true. And so we don't expect the nation to fall, but the nation is, in fact, the rights we're talking about. The nation wasn't Lincoln. It wasn't the territory that Lincoln controlled. It was the Constitution he violated.
Any other questions here? Okay, in the back.
I guess my first question would be, well, first I'd like to say along with her, you can't break the rules to save the rules. But my question would be, do you think there was a case for impeachment on Lincoln, and do you think precedents would have been broken had Lincoln been brought up on charges for having violated the Constitution?
It's funny because I testified in the Clinton impeachment. The idea of going into another impeachment during any age, enough to send you into a fetal position. But yes, I think that Lincoln could have been impeached because he most certainly committed high crimes and misdemeanors. In fact, I can't imagine a more important one than to deny habeas corpus to an entire nation. But this is part of the problem that we have. Convenience is the enemy of principle. And presidents have routinely violated the Constitution and called upon Congress to retroactively clear their name. And Lincoln succeeded in doing that. So impeachment wouldn't have been successful after Congress came in and essentially did retroactively authorize it. But if they had not, yes, he could have been impeached, in my view.
The critical factor here is who's in charge of Congress. And at the time, and through his whole administration, it was Republicans. So they would not have done that. Had the Copperheads been in control, I think they probably would have.
There's a question down here, I think. Yeah, right here.
Okay, so just to kind of bring it forward to today, I don't know a lot about politics. I'm just barely kind of wading into it. It's been very intimidating for me. I've always been fascinated by the Civil War, but I think it's mostly for Jennifer, but I think Jonathan has a lot to say too. But the presidents in today's time frame and in the last couple decades have used Lincoln as an excuse and a sort of loophole to get away with the things that they've done. And because as a nation, we look at Lincoln as an icon, and not a lot of us go that much further into it because, through school, we're taught that Lincoln was an icon. He's responsible for the things that are here today, until, of course, we get into college. But a lot of people have the thought that Lincoln is responsible for the country as it stands today. But a lot of, as you've said, and I've learned today, that a lot of presidents are you saying, have used the things that he did during the Civil War as kind of a loophole or he did it, so I can do it sort of situation. And if that were the case, if people had seen that more and stop it, we would be less war-driven because we've seen a lot of it in the last decade. But yeah, my question basically is presidents using Lincoln as an excuse rather than an example.
I think they use him both ways. I think it's two sides of the same coin.
I actually think that part of the problem with what came from Lincoln and has really blossomed in an ugly fashion in modern times is what we talked a little bit about yesterday. And I have to admit, I'm a critic of functionalism in constitutional interpretation. But this is an early example, this sort of relaxed view of separation of powers that you find in functionalist constitutional theory. And the majority of law professors tend to subscribe to functionalism. They tend to not put as much what's called formalist attention on the separation of powers. I actually think that many of the problems that we have had in history would have been avoided with a greater sense of formalism because it would require Congress to take affirmative acts, including the declaration of war. And we see much of our problem is the fact that Congress was more than happy not to have to declare war. You know, I'm as a typical Madisonian scholar, you know, I tend to view the separation of the three branches as sort of like Animal Farm, where all animals are equal, but some are more equal than others. In the three branches, all branches are equal, but really Congress is more equal than others. It's where the magic happens in the Madisonian system. And as much of an advocate as I am for legislative power, and I admit to be that, Congress has failed, just as the Supreme Court has failed. Many politicians want this cup to pass from their lips. They want presidents to act. You saw that with the Iraq War, where John Kerry and Hillary Clinton and so many others said, oh, I was misled, even though many of us at the time said, how could you vote for this authorization that is so absolutely ridiculous, how broad it is. And then they just said, well, you know, we didn't know what we know today. So it's clearly a failure politically in that sense. But to answer your question is we would have been better off with a more formalist view of these powers. And, you know, it doesn't help that it begins with such an iconic figure. You know, in preparation for this panel, I took my kids to Disneyland and went and saw Lincoln at Disneyland. I was sitting there and I felt my kids had to see Mr. Lincoln, which they were completely underwhelmed by. And, but I was sitting there thinking, of course, you know, this really is, the Lincoln that most people know is the Disney Lincoln. And it's I actually love it. You know, I love it. It's pretty cool to me, even though if my kids hated it. But it really is the Disney Lincoln, and you feel elevated when you hear his words. And it's easy to forget that he was exercising powers that were not his own.
Others? Oh, right behind you here.
Lincoln classified the Civil War, as you pointed out. He was very careful to make sure he classified it as a rebellion. And because of that, he was able to react quickly and claim a lot of war powers from that. If he would have accepted that it was a civil war, what would have been the constitutional course of action, Mr. Turley? And then, Jennifer, what would you say, or would you say that would have worked? And what's your opinion on it as well?
I think Lincoln was one of the best, maybe the best lawyer. No, I can't say that because you have John Adams, who was extraordinary, and of course Madison, if you include him in the sort of legal rubric. But certainly John Adams was an amazing lawyer, even though John Adams, of course, advocated the Alien Sedition Acts, the darkest, without question, the darkest chapter in our history. But he knew to avoid the term Civil War. But in the end, I think it probably wouldn't have mattered. This was a muscle play, and Lincoln knew he could get by with it. Remember, Washington, D.C., I live in McLean, Virginia. There is a single bridge that separates me from the White House. I work right near the White House. It is 10 minutes drive from my house to my office next to the White House. Lincoln knew that people in Congress staring over the Potomac would give him whatever they want, because right over that river was the Army of Northern Virginia. So I think it wouldn't have changed, but he knew that he wanted to claim at least the patina of legality.
Right. I agree.
Then you don't have to go to the fort.
Thank you. For now. This may change. I think, though, that Lincoln is also dealing with the question of whether secession is legal. And according to his view, secession is not legal. The Constitution is silent on the terms of membership. The Copperheads are saying that secession is entirely legal because the Constitution doesn't say it's not. Lincoln's argument is that the nation predates the Constitution. So he's looking at the Continental Congress, for instance. He's looking at the countries existing under the Articles of Confederation. This is his argument, which is why he's making this case that this is a rebellion, that the states are in rebellion and not in civil war. The Supreme Court doesn't rule on this question of secession until 1869 in a case called Texas v. White. And it rules that secession is illegal. By that time, of course, I think the Civil War had really decided that question already. But the critical thing to me about whether this is a rebellion or a war is that I believe it's the habeas corpus section says that habeas corpus can be suspended in times of foreign invasion or domestic insurrection. And the Civil War is nothing if not a domestic insurrection on a large scale.
Yeah, the word is rebellion.
Is it rebellion?
Right.
Okay. So this is the hook also that Lincoln is working from.
Yeah. Now, I should note that Sir Christopher would like to ask a question. I'm sure he's going to talk about how his predecessor supported the Confederacy in the Civil War. So please make sure we can hand him the mic, because this is going to be a truly wonderful moment.
Well, thank you very much, Jonathan. Well, I'd like to try and I'd actually like to try and be the peacemaker here and bring the panel together by asking a question from outside that will give you something to unite against, which is, why shouldn't the Confederate States have been allowed to secede? What's wrong with secession?
My God,
After all,
I was
the
right.
United States has backed it in relation to the collapse of Yugoslavia, Kosovo secession from Serbia subsequently. You did yourself arguably secede from the United Kingdom, from British rule. Now, if you leave aside slavery, which I grant you is leaving aside a very large elephant in the room, slavery which, by the way, the colonial oppressor had abolished in all its territories a generation earlier. So, you know, just that we set the scene for where civil liberties were really being observed in all this. How can a nation which is born out of a claim to a right of self-determination then deny its own component parts that right of self-determination, and then turn round a generation or two later and insist that other nations must allow secession? Woodrow Wilson was fanatical about it. Perhaps that's because he was a Southerner as well. So that should give you something to unite on against a common enemy.
Yes, well, that's wonderful.
You're saying the exact thing that the Confederates themselves said, that what are we doing that is so different from what the founders did versus England, that we think our liberties are being imperiled and so we're leaving, which is exactly what the 13 colonies had done. That's exactly what they're saying. What people in the North, Lincoln and his allies, the Republicans and the war Democrats at least, it's difficult to get inside their heads from our vantage point, right? But as a historian, this obligation is incumbent upon me, is to try to understand where they were at the time. From our perspective, it is really difficult to understand, okay, so the whole country would fall apart because half of it secedes? Is that really likely to happen? From our vantage point, 150 years later, well, maybe not. But we've got 150 years of the United States continuing and thriving to fall back on, and in our collective memory. They did not. This was a country that had existed for 77, so 80-odd years. They did not have a certainty that the country could continue. History is littered with stories of failed republics. So the people in the North were not at all certain that the country could continue to exist if it divided. And that was what is in their heads. And you have to consider the context of their time, not ours. And we cannot impose the judgments of our time backward on them.
Now, if the South did secede, would that open an opportunity for other countries abroad to have influence? I'm thinking of...
I wonder what countries those would be.
Mexico sound familiar to you?
Actually, it was funny because when I spoke at the Magna Carta anniversary recently, your esteemed colleague brought up this very point. So it appears to be a mantra that pointing out that England, to its great credit, did in fact not only oppose slavery, but became a very active opponent of slavery, pursuing slavers. And that would be a wonderful record, as I pointed out to your colleague, if it wasn't for the Alabama and other efforts of the English to help the Confederacy prevail in a war to preserve slavery. So that was a rather mixed legacy for Great Britain. But I guess the answer that I would give is I actually do think, as I mentioned earlier, that John Calhoun had some very good points. And I see, of course, your point. And it continues to baffle me as we look at the right, for example, Ukraine and other issues of when countries can remove themselves. The United States often does, in fact, support breakaways when we fought a war against that notion. The only thing I could say about the argument for Lincoln, particularly from today's perspective, is really twofold. One is the Constitution itself doesn't have an express means for secession. So one of the most obvious arguments is that there is no provision for secession. You agreed to a Constitution that has no exit ramp. And that goes to this idea of this covenant of faith, this contract that we had. You didn't just simply join a physical territory. You joined in a constitutional system that does not have an option to remove itself. And to support that, I think you could easily note that there's a difference between the Articles of Confederation period, when I think the argument would be strongest for secession, and then the post-constitutional period. And the difference is that the Articles of Confederation period, the sovereignty of those states was robust. They really were treated as sovereigns. It was an utter failure. You had all of these different states going in different directions, even printing their own money, doing other acts short of secession that suggested their independence. But then we all agreed to the Constitution. And that Constitution, first and foremost, recognized the centrality of the federal government and also the commonality of the nation. In some ways, you could view that period as when we stopped being Virginians and Alabamans and started to become Americans. But it was in that act of adopting the Constitution that I think that you could say you gave up your right to remove yourself because you were agreeing to this system that we would resolve all differences through this process. And that system included a number of things that you could do as states, but it omitted the one thing that you are now claiming, the right to remove yourself from the process.
But the lack of clarity on that had been problematic for really since the inception of the nation. You have northern states who are threatening to secede with the Hartford Convention in 1815. You have South Carolina, which is making noises about seceding during the nullification crisis. So that was really an open question, I think, until the Civil War, and I think the Civil War really settled
That's
that.
a fair point, absolutely.
Well, you see, it worked. I've brought the panel together. And Jenny, if you'd be kind enough just to give Jonathan the anatomical Lincoln doll so that he can hold it for a few minutes, we've actually succeeded. But, you know, I take the point that there's nothing in the Constitution about secession, but there wasn't in the Constitution of the Socialist Federal Republic of Yugoslavia or of the USSR. There certainly wasn't anything in the Austro-Hungarian Imperial Constitution about that. And while the argument is seductive, isn't it, that these 13 separate states came together and voluntarily chose to create this union, by the time you get to 1865, there are as many other states that weren't part of that original group, and with the exception of Texas, had never had an independent entity, an independent existence. And Texas, you may remember, did actually put out overtures to another state to see whether they were interested in coming along and helping out, and were bullied out of that. You know, they weren't allowed to become part of the British Empire. We would have welcomed them. They actually had an embassy in London, you know.
But what you're asking of the United States is for it to be consistent in its ideology over 150 years.
Principled would be the word I would have chosen, but no, I'll go with consistent.
But I think that's a lot to be asking.
Well, I guess what I would point out is Yugoslavia is an interesting example, and I think your point is obviously a brilliant one. It's absolutely correct. Although Yugoslavia is an interesting comparison because this was essentially a collection of largely independent and warring states. The difference, I think, is that the Constitution of the United States did create some level of homogeneity in one sense. It reaffirmed American status. You essentially bought into the system, that we would resolve our disputes through the system in a way that I don't think is true for Yugoslavia, but I take your point for whatever it is. I must say, whenever your predecessors came to unite us, it has worked, like when you burned down the White House. And so we appreciate these moments of clarity.
That was a reprisal for burning down Toronto, wasn't it? Just so that we know which anatomical doll each of us has to look at now.
Really
Okay,
regret
we're
Toronto
going to
burning
have
down.
we've used up that time, and I really want to thank both speakers. I would like the audience to give your appreciation to our speakers here. Thank you very much.